25 MM6 set for case management. He is currently unrepresented.
Good morning, Ms. Williams. You're here for case management on one count of driving while license suspended, resisting or obstructing officer without violence, and failure to register a motor vehicle. My understanding is that you do not have an attorney presently, and I think I received a number of filings that you filed 4 filings this morning with the clerk of court. I had a chance to briefly review them. So before we proceed, would you like to have an attorney appointed to represent you?
I represent myself.
Okay, so we'll address that in a moment. Mr. Helling, I think that I saw that Judge Bishop had notes in this case about having this case set for trial if there's no movement in this case, because I understand, Ms. Williams, you don't intend on entering a plea.
I'm sorry, I'm 75% deaf. I almost didn't hear any of that.
Sure, so I'll try to speak a little bit louder. Ms. Williams, my intent today is to set this case for a trial.
You're gonna address the jurisdiction challenge?
Yeah, it's legally insufficient, it's denied. We have personal jurisdiction over you because you live in the state of Florida and you were operating allegedly a motor vehicle on the streets or highways of Union County. So we have personal jurisdiction over you. That's going to bring me to the next point, which is you indicated that you're pro se and that you do not intend on hiring or having an attorney represent you. Is that correct?
From this point on, I'm invoking constitutional law in this courtroom.
Okay, I intend to follow the U.S. and Florida Constitution, so we're on good standing.
And reserve all of my rights. And at this moment, I'm going to choose to invoke my right to remain silent. And because it's a criminal court, my silence cannot be construed as consent or guilt.
Okay, so here's what I'm going to do is I'm going to ask you some questions about whether or not you understand how to represent yourself. If you choose to remain silent, I will appoint an attorney because you've refused to answer my questions.
I reject that.
Okay.
I object. Excuse me.
All right. So, have you ever studied law?
Yes,
All
for the
right.
last 4 years.
Have you ever represented yourself in a criminal action before?
I know I stay out of trouble.
So is that no?
No, I never, does that matter?
It does, because it goes to your knowledge and ability to represent yourself as well as to understand and
I'm
appreciate
very
the-
competent. I'm not to be presumed ignorant.
Okay. Do you understand each of the charges against you?
No, I do not.
Okay. So you are charged with one count of driving while license is suspended or revoked, which
What was
means...
the probable cause to pull me over?
So that's not what I'm asking you right now.
That has to be put on the record before any proceedings.
Okay, well,
by law.
so you were charged with driving while your license was suspended or revoked.
I wasn't driving. I was wrongly accused of driving. I invoked and clearly, would you like to see?
I'm gonna be talking for a little bit, and so I would like you to listen to my questions. This isn't a chance for you to try your case. This is for me to decide whether or not you're competent to represent yourself at trial. Okay?
I am.
Well, I will make that decision. So you were charged with one count of driving while license suspended, one count of resisting an officer without violence, and one count of failure to register a motor vehicle. Do you know the maximum penalty for each charge?
No, I don't.
Are you familiar with the legal elements of each charge?
No, I don't recognize policy. I don't
That's not
recognize
my question, which is...
administrative law or statutory law.
Well, you may not recognize it, but it will be imposed on you, and if you are found guilty, the judge will impose a sentence whether or not you recognize it or not. Do you understand that?
If you force jurisdiction where there is none, you'll be open doors to impeachment and lawsuits.
Okay. Well, I probably won't be the judge trying the case, so that's okay with me.
Your Honor, if I may, I think that Judge Bishop has gone over these with her already, and she is once again maintain her
Sure.
proceed pro se.
I think that if I'm setting for trial, I think just to be safe for every stage, I'm just going to go over.
I was going to say, this is case management. It would go to pretrial next month. And then
Okay.
trial after that. So I think we're one step away from setting it full trial.
I'm going
All right.
to fire any judge, any attorney that's been appointed.
All right, guys, today we're diving straight into a courtroom clash that escalates faster than anyone expects. From the opening minutes, the defendant's tone is openly combative, challenging authority at every turn. The judge tries to establish basic order and procedure, but interruptions begin almost immediately. This opening segment sets the stage perfectly, a courtroom trying to function versus a defendant determined to resist control.
To me, so
Well, so I guess, Mr. Salter, if I set this for trial, would you be willing to be standby counsel just in case?
I think I would need to be, yes, sir.
Yes, all
he's
right.
fired.
Well, you don't get a fire standby counsel.
I do not consent to that.
Well, that's the thing about this, is that there
I have a right to represent myself. I've done
You
made
do.
it clear.
You have the right to represent yourself.
Yes.
But also the other part is that you have to be fully aware of
Yes,
all the risks that come with it.
I'm willing to take any risk.
Okay. I'll just put it this way, having read your legal filings, as well as the arrest report, I think you fundamentally misunderstand the laws and
Nope, I
constitution.
am not. The Amish community has well kept up
Sure.
that right.
I'll just put it this way, I don't see many Amish people driving
Well,
cars and using
you're looking
phones.
at one.
Your Honor, we don't really have a trial week next month, so we'll just put, if you could put this on pretrial conference for the next month,
Yeah.
Judge
Well,
Bishop can
when is our pretrial conference?
June 10th.
So it's the same day as case management?
Yes, Your Honor. We only have one misdemeanor court date.
All right, so I'll put your case on for pretrial conference. Be aware that you are charged with driving while license suspended and resisting an officer. Both of those are first-degree misdemeanors. Maximum punishment of those consecutively would be up to 2 years in the county jail. Failure to register a motor vehicle, that's a second-degree misdemeanor, which is punishable after 60 days in jail. So you could find yourself spending up to 2 years and 60 days in jail on these charges. Do you understand that?
No, I don't. But
Okay, so here's what happens is if you're found guilty, because what the state's required to prove are the essential elements of each charge.
I have all that.
The essential elements of driving while license suspended is that you were operating a motor vehicle on the streets or highways of Florida while your license or privilege was revoked or suspended.
I still don't
Whether or
know
not
the
you were
probable cause.
traveling, flying, or whatever you want to describe it, if you were in a car and that car was moving and you were operating that car and your license was suspended, then the jury would be instructed that all essential elements have been proven and they should find you guilty. Likewise, resisting an officer means that you resisted, obstructed, opposed an officer in the lawful execution of a duty, but you did not offer violence during that. If they find that you committed that offense, you would be found guilty and could be punished by up to a year in the county jail. So with that, you wish to have this set for trial.
no, I do not. But
Okay,
I
well,
wish
so
to
your
have it
options today,
dismissed.
your options today are to enter a plea or set it for trial.
You make the call.
Okay.
I'm not going with any plea, so
Okay, then we'll set it for trial. So that's how the case will be resolved. We'll set you on for June 10th for pretrial conference. Please sign notice and we'll see you then.
thank you. May I address the court, please?
That's why your case was called.
Article 6, Clause 2 of the United States Constitution says, "This Constitution and the laws of the United States, which shall be made in pursuance thereof, shall be the supreme law of the land, and the judges in every state shall be bound thereby, and anything in the Constitution or laws of any state to the contrary notwithstanding." This means no state law, no local ordinance, and no traffic code can override the supreme authority of the United States Constitution, especially when it comes to the fundamental liberties of the people. I am here today as a special appearance, not because I committed a crime, but because I exercise a federally protected, clearly established constitutional right, which is the 14th Amendment right to travel in my private automobile without government permission or interference.
All right, stop. I don't have time to deal with this, and I'm not going to listen to this. Everything you're saying is absolute nonsense.
No, it's very true.
Stop talking. Don't talk. Don't talk. Everything you read about, when you read from the Constitution, yes, you read that correctly. Your interpretation and everything you think you're doing is absolutely wrong. The writ of prohibition that you filed in the First District Court of Appeal was dismissed yesterday, and we received that order, okay? I don't know what you think you're going to get by filing a writ of prohibition in the United States Supreme Court. If they even choose to answer that, we'll wait to see if there's an answer to that.
I will.
All of your claims are absolute nonsense, and I don't have time to deal with them. You were charged with driving on a suspended license, resisting an officer without violence, and failure to register a motor vehicle. Stop. Don't talk. The state attorney's offer to you is an adjudication of guilt, a $100 fine, court cost, and cost of prosecution.
Judge, to clarify that offer is no longer open.
That was the offer, okay? So there you go. The state attorney revoked the offer. Very, very good. This is pretrial conference. And I don't have time right now. I just don't. I have to end our docket today because I have another appointment to go through a Ferretta hearing with you right now. But you have indicated previously that you want to represent yourself, and so far you have been representing yourself, and with that being all the state had previously been asking for, that's all we would have done anyway. Okay. So you're not going to like anything I'm going to do right now, okay? And you're probably not going to agree with it. If you want to file all of the nonsense that you've written down on paper and file it with the clerk, you certainly can. And then you can appeal any decision that I make to determine whether or not I've acted within the laws of the state of Florida, okay? I'm going to temporarily, because I expect that you're probably going to want to represent yourself if that's what you want to do, but you do have the right to have a lawyer represent you, and it sounds like the state's going to turn a little harder toward a more severe punishment. I'm going to appoint Mr. Salter to represent you today. I want you to at least try to have a conversation with him. And if you...
In this part, the judge repeatedly explains routine legal procedures, while the defendant reframes everything as a personal attack or rights violation. From a third-person perspective, it's clear the court is offering structure, not hostility. The defendant, however, treats every instruction as provocation. This stretch shows how misunderstandings, real or intentional, start turning a standard hearing into a prolonged confrontation.
If you don't do that, well, we'll deal with that later. I'm going to continue the pretrial conference to the July docket. And at that date, if you indicate to me that you want to represent yourself, then we'll have a Ferretta hearing on that date.
That's fair.
I'm not going to hear anything else from you today. I don't have time to deal with it.
I understand.
If there's something that you want to file, you can write until your hand bleeds on your paper. You certainly are free to do that, and you can file it. Whether it has any merit or not, I'll make decisions that I have jurisdiction to make, and then the appellate courts can make decisions about the jurisdiction, about the things they have jurisdiction to make, to include my decisions and my legal opinions. Okay? I'm not going to deal with all of this today. All right? Sign your notice to appear for July 15th, and I'm appointing Mr. Salter to represent you for today.
That's the last case on the docket.
Right.
Your Honor, just for the record, I know that you appointed me to represent Ms. Williams the last time. She has not contacted me and has no interest in me representing her, so I'm going to sit.
I understand that. And Ms. Williams had, and I'm going to go through some things with Ms. Williams. I'm going to allow her some time to talk.
I can't hear you. You're going to have to speak up.
You need the hearing, we have hearing aids.
No, that's nasty, disgusting, dirty. You don't even...
All right, well, I'm not going to
talk
shout.
about it.
Ms. Williams, I'm not going to shout, okay? All
You
right.
did the first time, so...
No, I didn't. I've never shouted at you.
Well, then, do you have any other accommodations for handicapped people?
I have these hearing aids. They've been cleaned off and sanitized.
No, they're not. They've been cleaned off. They're not been replaced. I'm not putting something that's been in someone else's ear
All right,
in my own.
You obviously can hear what I'm saying to you, correct?
Not because you raised your voice a little.
Okay, thank you.
But I didn't hear that.
Let's keep our tone civil if we can. Can we do that?
Yes,
can we
I
maintain
can.
civility in our discussion? I'm going to allow you
I
some time
talk
to
loud
talk.
because I'm deaf.
Okay.
So I'm
You have
just
it. You have
stating the fact that We talked about that prior, the very first case I was here, I couldn't hear, so.
Okay, we've had many conversations here on the record, and that hasn't been an issue before, but I'll do my best to speak
That's
up.
because you screamed at me last month, so, I didn't have no problem hearing that.
All
So,
right.
yeah, okay.
Miss Williams, I didn't scream at you. Everybody in the world has seen the video you posted of our court proceeding
Yep.
here, okay, to include myself.
Only 600 something.
That's great. I have no problem with anything that I said in your case, so you do what you feel like you want to do.
The JQC had a problem with
It
it.
does appear, and I will say that it does appear that you properly requested through a public records request to get the recording of what we do here in
Yeah, I
court.
did.
And that's
Paid
what you
for it and
published.
everything.
I want to caution you and anyone who's with you that if you privately record anything in this
I ain't
court,
probably recording anything.
let me finish talking. Stop interrupting me.
just proving it.
Because
Sorry.
you need to hear this. If you privately record anything in this courtroom, then you'll be in violation of the administrative order that prohibits such recordings, and I will proceed with contempt
That's fine.
proceedings. Do you
As long
understand?
as they work, I'm good.
That camera's working, everything's being recorded. You request away under Chapter 119 for all the public records you want. I have no problem with anything I say here on the record, okay? All right, I understand all of the things that you filed. I want to make it clear for the record that there are several things that you filed that I have determined are not legally cognizable.
Some of them were just, just letters not
Sure.
meant to be.
Okay,
So,
I
yeah.
have stricken those things that I found to be legally not cognizable.
What exactly are those things?
Again, you know how to do a public records request, so you can request your court file and get a copy of
get
the
ignored.
things, okay? You stop interrupting me when I'm talking, all right? I entered an order striking several of the pleadings. You did file one where you objected to the forced appointment of the public defender. And that, I believe, does legally trigger a Ferretta hearing. And so I did set today to have a Ferretta hearing with you, to go through the colloquy with you, to allow you to represent yourself if I find that you're doing that knowingly, intelligently, and voluntarily. Do you understand that?
We first have to establish jurisdiction on the record before we can do that.
No, jurisdiction is, I do not have to go, that's the.
You have to have both jurisdictions before you can proceed. You don't have either one of them. Neither one of them have been proven on the record.
All right. What is it that you think? I'm going to entertain
I
you for just a
already
minute.
said them
What
to
is-
you,
What is
so-
it that you think? Well, say
I have a whole
say it
list.
here on the record. What is it that you think compromises this court's jurisdiction right now?
Is constitutional violations. This court clearly does not honor the Constitution, so therefore it's not a federal court. It needs to be moved to a federal court because my rights were violated from the start.
Your charge
The
of,
initial traffic stop
your charge
was
of,
unlawful.
your charge of driving on a suspended license, resisting an officer without violence, and failing to register a motor vehicle, all violations of Florida statute, you say
Florida
belongs-
statute.
You say
I was
belongs-
exercising federal protected
Okay.
rights that
this is-
Florida
this
has
is-
to honor
Ms.
as well.
Williams, this is the nonsense part I'm talking about. This is what we've been through in the past, and this is, I cut you off last time simply because I didn't have time to go through this kind of dialogue.
You didn't have time when you
didn't.
were on the clock.
I sure did not have
I
time to go
bet.
through
You saved my case for very last.
And look where you are now.
Yeah, now.
Not last.
Trying to prove me wrong ain't proving nothing wrong.
But you should realize that actually having you go last might save you a little bit of public embarrassment, but here you are.
There ain't no
and
embarrassment.
everybody's
I'm
watching.
speaking truth, and you're silencing the truth to
All right.
keep these people from learning their rights.
Let's go through the discussion about whether you represent yourself. Can we do that? And can we do that?
No,
with-
we have to discuss jurisdiction first. It has to be proven on the record before we can proceed. Otherwise, I don't consent to any proceedings before jurisdiction has been established.
As your lawyer, I can tell you.
You're not my lawyer.
If you
right.
let the judge go through this inquiry, then I'm not your lawyer. Then I'm officially not your lawyer. Then you can make your arguments.
There ain't no argument. The only argument is this
All right.
judge does not honor our constitutional right.
I'm-
Doesn't honor the law.
I'm trying to go through the questions that I am required to go through under the law before you are to represent yourself.
You're required to do this too.
Okay.
We have to do this before, you don't have jurisdiction to even determine a Ferretta hearing. That's why this has to be said first.
You think this needs to be in federal court and that I have
Yes,
jurisdiction?
my federal rights. You do not acknowledge or respect the people's right to travel in this country. Florida is in America. Our Constitution supersedes all state policies, laws, or whatever. And you're not accepting that. That's fact.
This is the part where you don't actually understand how.
I do understand it.
Works.
Constitution was made for the simple man to understand. It's very easy to understand. Supreme Court has made precedents even more clear for people to understand. The very many that I sent you, which is absolute clear, you're refusing to acknowledge.
I actually read through several of those cases just to double check.
They don't have to be about being pulled over.
Here, frustration becomes undeniable. The defendant pushes hard for self-representation, framing it as an absolute constitutional right. The judge calmly explains the legal standards required before that can happen. As an observer, you can see the turning point. The judge begins linking the defendant's own behavior to why the request can't move forward. Conduct, not opinion, becomes the deciding factor.
For no drivers, like it's all protected rights.
You're citing dicta, or you're citing holdings that apply to a different application of that constitutional right. None of those holdings.
They all have.
None of those holdings said that a state cannot require licensure.
Yes, it does.
For a driver.
Yes, it does.
No, it doesn't.
I will have them
See,
when we go to trial.
I can't have this nonsense discussion.
It's not nonsense.
We can't get anywhere.
You're not recognizing it as truth, so you're calling it nonsense.
Will you go through the Ferretta inquiry with me? Because if you will, then we can have this. No,
that would be be me giving you jurisdiction over me in this case, and I'm not going to do that.
All right.
You have to acknowledge the personal jurisdiction. I have a whole list here. We can go over each one if you want.
I want to allow you to represent yourself if you can go through those questions with me. But if you continue to be obstreperous the way
Let's
you
go
are
through
right
these
now,
first before we can go through that.
Here's the other part about court and jurisdiction is that you, Ms. Williams, as the defendant in court, do not get to tell the court how to conduct procedure in court.
A court cannot determine its own jurisdiction.
Very clearly. Do you understand that?
I overstand.
Okay. I don't know what that means when
I know.
you say that. Okay. You have graced us with your intelligence in all of your pleadings, and those are all a matter of record. Okay? And if I have made some decision here today and your case results in a conviction at some point in time, then the appellate court can review everything that you wrote and everything that's been said here and determine whether or not I've made a legal error. Determine whether or not
I think the JQC is going to determine that in 3 days.
I welcome anything the JQC has to say about what's going on in this case. I certainly
How about we continue this until next month and then determine on that? Can we do that?
You don't get to. You can make a request.
That was a request. I asked. Can we do that?
Stop trying to tell this court what it's going to do. Do you understand that?
I'm being forced to be here under threat, duress, and coercion. I'm not here voluntarily.
You're giving me no.
And I'm not.
Stop talking. Now I'm going to stop you because you won't stop. I'm trying to give you a chance to speak. I'm trying to give you a chance to.
But I wasn't
done. Stop talking. Now I didn't raise my voice, and I did. Yes. Stop talking. If you say another word, I'm going to have a deputy escort you out of the courtroom. And I'll give you a chance to cool off, and then we'll give you a chance to come back in if you think you can behave like an adult. Okay? I'm trying to give you the chance to represent yourself. What you're saying about the court establishing jurisdiction is one of those things that is not legally cognizable. It isn't. Okay? I know you believe it is, but I'm deciding and determining here that it's not. The next order of business is that you did file a legally cognizable request to represent yourself. You did do that. And I want to give you that opportunity. I'm required to actually give you that opportunity, and I want to try to give you that opportunity. Stop talking, okay? I have to go through those questions with you in order to allow you to represent yourself. That would give you more ability to, in fact, file some of these pleadings, and I wouldn't be entering an order striking them because of dual representation. they would remain on the record, or they would be stricken as legally incognizable, but they would remain there in the record so that any other superior court can determine whether or not I made a legal error. But I can't get to any of that if we don't go through the Ferretta questions. And if you continue with this obstreperous behavior, with this disruptive behavior, then I will have no choice but to require that you have a lawyer and require that you sit at counsel table during a trial and not say a word until it's your opportunity to testify in your own defense if you so choose, and you will be given that opportunity because you are entitled to that under the due process of law and under the Fifth Amendment, okay? And you also have the right to remain silent, either one. But up until that point, I will require you to sit there and let your attorney argue your case. And yes, subsequent to Ferretta, there is other case law from the United States Supreme Court that says that when a defendant is disruptive in court and cannot comport themselves to proper courtroom decorum, then I do not have to let you represent yourself. I do not have to waste the people of Union County's time in a jury trial having you spout hours of nonsense to them that has nothing to do with the decision that they would have to make about whether you were guilty or not guilty of the offense that the state has charged you with. I'm going to give you one more chance. Do you want to go through the Ferretta questions with me now so I can determine whether you can represent yourself?
I'm invoking my Fifth Amendment right to remain silent, and once again, my rights will not be interpreted as consent or guilt because this is a criminal trial.
All right. Mr. Salter, I have to leave you on this case. I will enter an order indicating that I'm not going to allow Ms. Williams to represent herself unless and until she can demonstrate to the court that she can change her behavior and actually just cooperate with the court's procedure. Cooperating with the court's procedure has nothing to do with you admitting or denying guilt. You can say one more thing. Go.
This is not a federal court. Federal crimes were committed against me in the initial traffic stop. It took this jurisdiction right away from you.
Okay.
And you're forcing jurisdiction.
Your Honor, I'm asking to continue the pretrial conference one more month so that perhaps she can have what she wants from the JQC inquiry, and then we'll see where we are next month.
Absolutely. I think you said something about them meeting today, or in fact,
3 days or something.
3 days from now, yes.
3 days from now. That's great. Well, we'll see how that goes. You should try to meet with Mr. Salter. You should try. Look at that, Mr. Salter.
I just thanked him. I'm a very kind person.
Look at that. He's looking out for you. He's actually doing
Well, he did that one other time also, too, when Judge Wright was here. He did look out for me then.
What's our name?
Acknowledge that as well.
Pre-trial conference is continued to August 12th. And we'll see where things are from there. At this time, you're not going to be allowed to represent yourself. I'll give you one more chance on August 12th to determine whether or not you can change your behavior. Ms. Williams, before we address anything with regard to your case,
I can't hear you.
the only thing I can do is...
This segment is dominated by constant over-talking. Every attempt by the judge to complete a sentence is interrupted, and the courtroom rhythm completely breaks down. From the outside, it's obvious this isn't just rudeness, it's being documented. The judge stays measured, but the record is being built carefully, showing repeated disruption rather than isolated incidents.
I'm not going to shout, okay?
I'm not asking you to shout. I'm just speak up a little. I
Okay.
couldn't hear anything back there at all.
All right. I'll do my best to accommodate you. All right, we've offered numerous times
I'm not
to give you
going
the
to put
hearing
something
aids.
that's not replaced in my ear.
Okay. Well,
You're not accommodating a handicapped person in this room.
that-
You can speak up a little bit because you have the rest of the times.
okay. Thank you for so politely telling me how to do my job, Ms. Williams.
I'm just
I
asking.
appreciate that.
I
That
mean,
is wonderful.
I can't hear.
All right.
If you want a successful hearing,
Okay.
you need to be able to let me hear it.
I need you to listen and don't interrupt me for a few minutes because I have some very important things that I need to go over with you about some of your conduct in court. Okay?
What conduct?
Listen and don't interrupt. Do you understand? Okay. You have exercised your right under Chapter 119 of Florida statutes 3 different times to obtain public records of this court proceeding. You did that on May 13th, 2025. You did that on June 6th, 2025, and you did that on July 15th, 2025. Each time that you made that request, in the process of making that request, you would have been required to go on the circuit's website and read the notices on that website about prohibitions of dissemination or publication of that information that you receive. When you received the recordings, it appears that you received them pretty promptly after the request. They were sent to you electronically by the court reporting services here in the circuit.
Yeah.
There's a very large banner circled in red, highlighted or bolded, that says dissemination of this recording to any other person is strictly prohibited except as permitted by law, rule, or court order. In that process, we are enforcing in this circuit Florida Supreme Court Administrative Order AOS or SC 1122 that requires that any audio or video recording that is released to a non-party shall be redacted of any confidential material. And this court, through its process of you requesting that information, has instructed you. I have not verbally instructed you. I'm about to do that now. But through your process of requesting these public records through our channels here, through our online service, you were instructed through those notices that you are not permitted to disseminate that information. Okay? And when you receive that information, not yet. You were told that you cannot publicize that information. You're entitled to have the records of this court proceeding. You as a party, you and your attorney are entitled to have those records. What you're not entitled to do is to publicize unredacted portions of that proceeding or any portion of that proceeding without the permission of the court. And there are some good reasons
they were redacted.
How were they redacted? Explain that.
Because I've checked the one that doesn't come with the hush order. So in ordering them that way, I did not order. They gave me whatever they give me. It does not say anywhere on that website. You cannot post them publicly. They all knew I was doing it. When I ordered it, I told her on the phone. She said that's fine. Nothing was told to me about that. There's no big sign that says you cannot. There's two options. There's a redacted and non-redacted. The one comes with a hush order. I didn't order that one.
All right. I'm instructing you right now that after you have posted subsequent to each of those hearings, the May 13th hearing, you were in front of Judge Wright, and on June 10th and June 15th, you were in front of me, and you published on some type of social media the entire recording, and the entire recording that shows everyone else sitting in this courtroom. I presume that you may walk out of the courtroom and go request this hearing as well. You're entitled to have that record. You're allowed to have it.
I'm also entitled to post it publicly too. It's public forum. This is public.
I'm going to instruct that you are not permitted to post anything.
That's an unconstitutional.
All right.
That's an unconstitutional ruling, and I do not consent. I object 100%.
You don't get to decide whether you consent. I get to control.
You don't get to violate my rights.
I get to control this portion of the court
proceeding. You don't get to violate my rights.
Are you going to listen to me, or am I going to have you escorted out? Are you going to listen?
Say what you're going to say.
All right. Your attitude does not help you at all. No,
my attitude is not, my behavior has not been terrible. You just don't like that I'm not submitting to a public defender to plea out, and you don't like that I'm defending myself.
I don't care.
And that's why you gaslighting to the situation to make it out to be that I have a behavior issue. I've not once called anybody any names, screamed, or even was all over the place in here. So tell me how my behavior was disruptive last month.
All right.
I could not hear. I speak loud because I can't. I'm deaf. I'm deaf.
You don't.
So I speak loud.
You won't stop interrupting me or anyone else who's ever tried to speak during this proceeding.
I was told last.
Right there, I haven't finished talking and you jump in. You can't wait. You don't have any patience to be able to just wait and let somebody finish what they're going to say.
I can barely
you
hear
can't do it right now.
I can barely hear you.
You cannot resist it, can you?
What's the purpose of me even being in here if I can't hear you?
I give you ample opportunity to speak, but you don't. You try
No,
to
you
interrupt
don't. You
and tell me
silence
how
me
I'm
every
supposed to
time
do
I open
this.
my mouth.
Okay. Ms. Williams. I'm instructing you that you cannot publish anything on a social media account going forward of any of the court proceedings that you receive from this court, from the public records process of.
That's unconstitutional.
Let me finish what I'm saying to you. You can object to it, that's fine. You have the right to object, and I'll give you that opportunity. But let me finish what I'm saying. Right? You cannot publish anything on a social media account, okay? You cannot publish anything on any type of public website or YouTube channel or whatever brand of public dissemination. You can have the access to the record for yourself, for your own edification for court proceedings. You can't publish the record. We do court here, not just for you, but for other people. Other people in this courtroom don't want their faces or information potentially about their cases, or maybe even the fact that they're sitting here in this courtroom all over social media. They're not required to have to submit to that. They're not making public records requests. You are.
They're in a public place.
You have the right. You have the right to say whatever.
Object.
Listen to what I'm saying. You have the First Amendment right to say most anything that you might want to say about me and how you disagree with
I also
my
have a
proceeding.
First Amendment right to post my sayings online publicly. These people are here under threat, duress, and coercion.
Okay.
This is a public forum. So, yeah, I have a right to, so I'm not going to
All right.
follow that
Under-
unconstitutional order as I have a right to not.
All right. Under Florida Rule of General Practice in Judicial Administration, Rule 2.450 and Rule 2.451, I'm exercising the discretion to order you to not publish any public record, video or audio that you receive in the process of requesting it from these court proceedings. You can go on social media and say whatever you want to
I'm
say about me.
sorry. I can't do that.
I'm ordering you. If you fail
I'm sorry. That's an unconstitutional.
Social media enters the courtroom here. The judge issues a clear order to remove posted court footage and explains the legal consequences of refusing. The defendant flatly declines. This is a critical moment. It's no longer about argument, but direct defiance of a court order. As a viewer, you can feel the shift. This case is now flirting with contempt territory.
Order, you
fail-
cannot make it
Stop
lawfully.
interrupting me. If you fail to comply with that order, and if you fail to take down the social media posts that you've already made of this court proceeding, that again...
I'm not going to do that either.
Stop interrupting me. That again shows all sorts of other people in the courtroom. If you fail to take those down, then I will issue an order to show cause why you shouldn't be held in contempt of court. So I've issued that order. I will also issue that order in writing, and you and your attorney will be furnished a copy of it. All right. Do you have anything you want to say in response to that?
I
You're allowed
object.
to
I'm not going to do it.
Your objection is noted for the record. You're telling me that you're not going to do it. If it's determined at your next court proceeding that you haven't complied with this court's order, that I will initiate contempt proceedings against you. Okay?
When you going to do that?
At our next court proceeding. I'm going to give you the chance to comply with the order. I'm going to give you the opportunity to comply with it.
Can you tell me why?
Even though you're telling me that you're not going to do it.
Can you
Okay.
tell me why this is my fourth pretrial hearing and why I keep having to come back here? I'm not getting a trial at all. I just keep coming back for pretrials.
We were ready to try your case. I was going to let you.
But my behavior.
But see, you cannot stop interrupting. You're incapable of doing it. I don't know if it's an impulse control disorder or something, but you are incapable of just listening for a moment. Did you see how I finished talking a minute ago and stopped and said, now would you like to say something? It was a polite exchange like that. That's all I'm
And
asking.
then when I started talking, you overtalked me. So yeah, there.
You still can't do it. You can't.
You pause, so at what point,
you
so I'm
can't
just supposed to
help.
wait
I'll-
until you say you
Yes.
can talk now?
That's exactly right.
All right, then.
That's exactly right. All right. We have attempted to take your case to trial. You have no obligation to accept the state's plea offer. I don't care whether you do or don't. It's up to you to decide whether you want to do that. You are the only person that can decide whether you want to plead guilty or no contest, or whether you want to plead not guilty and take the case to trial, and you're entitled to a trial. In the process of trying to get your case to trial, you said you wanted to represent yourself. We attempted to go through that process. Judge Wright attempted to go through that process, and I attempted to go through that
we
process. And you would not listen to the questions for us to make a determination as to whether or not you're going to be allowed to represent yourself. And you have demonstrated such interrupting type of conduct
Right.
that I don't trust you will sit through the trial and let the state present its case without you not formally objecting, but just interrupting and causing a disruption of the entire process and a mockery of the court process.
I'm sure.
Okay. And again, the sarcasm and smart mouth remarks back to the court.
I'm being forced to be here. I'm not supposed to be happy and excited, am I?
So that's why I don't expect you to be happy and excited. That's why I've required you to have an attorney.
I don't have to have one.
You're right, you don't. But you have to answer some questions from me first for me to make a determination that,
No,
that
you
you're,
don't.
that you're
I'm
doing
confident.
this.
I'm very competent.
I have to ask
Do
you
you
some
have-
questions first to make that determination.
You have to have evidence to prove that I'm not competent to represent myself. Do you have my hospital papers that say that I'm whatever?
All right, I'm going to resist the temptation to respond to that. Ms. Williams, if you think you want to represent yourself, I will gladly give you the opportunity to do that, but you have to go through the questions for me.
No,
You have to,
I don't
you have to
either.
answer my questions.
You have to accept this jurisdiction challenge before you can proceed to that. And you've done nothing but
You-
silenced it, overtalked it, and you're doing it now. You're just shutting me up, not allowing me to speak, and when I do speak, you call it nonsense. You're trying to step on my First Amendment right to access that and post it publicly. It is in a public forum. I'm not going to comply with that. I'm not going to take down what I already posted because you can't silence me like that to the public. You can't do it, not lawfully. Would this happen to be because you were just served a civil rights lawsuit yesterday?
Has nothing to do with that.
I'm
It
sure.
has to do with the integrity of the court process and how you either use or misuse or abuse.
I didn't misuse anything.
You still can't do it. I'm still talking. I hadn't finished the sentence. Of how you either use or misuse your access to the public records of your court case.
I didn't misuse anything
Okay.
at all.
All right. You've heard my instruction. I've heard your objection. It's been noted. I'm aware of all the various things that you filed in several different appellate courts, whether it's the First District Court of Appeal, the Florida Supreme Court, the United States Supreme Court, or the U.S. District Court in Jacksonville. Let those proceedings play out as they may. Several of them have been dismissed as lacking any sense of merit whatsoever. Okay? So, no, it has nothing to do with, I received the very lengthy filing that you have filed against myself and the sheriff's office and other officials here in this county. So it has nothing to do with any of that. You're entitled to file those things, whether that court has any inclination to consider any of that. We will let that court do its job and not obstruct that process.
Can I
It
ask
can make its
questions?
decisions.
Can I ask them?
You may ask your questions. Go ahead.
Have you taken an oath of office to uphold the U.S. Constitution?
Many times. I'm going to answer that more thoroughly. I'm going to answer that very, very clearly. Because the first time I took an oath to support and defend the Constitution, I was 22 years old when I was sworn in as a second lieutenant in the United States Marine Corps. The next time I took an oath to support and defend the Constitution and the laws of the state of Florida was when I was sworn as an assistant state attorney in the 7th Judicial Circuit of Florida. And then the most recent time I swore an oath was when I swore to support and defend and protect the Constitution and the laws of the United States and the state of Florida to serve in this court So yes, I've taken an oath many times.
Then
And
are
I've
you bound by
reaffirmed-
that oath?
And I've reaffirmed that oath, my military oath.
In this section, the judge lays out, step by step, why self-representation isn't being allowed, tying each reason directly to the defendant's conduct. When questioned about his oath, he responds with a detailed account of military and judicial service. The contrast is sharp and deliberate, structured authority grounded in experience versus chaotic challenges driven by rhetoric.
Every time that I've been promoted.
Are you bound by that oath in every ruling in this case?
Absolutely.
All right, even the one that you just stopped me from doing?
Absolutely.
So, right? All right, so does your oath require you to uphold the rights of the people before enforcing statutes?
Yes.
All right, then if a statute conflicts with the constitutional right, your duty is to uphold the right, correct?
If a statute conflicts with a
Constitutional
Constitutional
right,
right.
it's your duty to uphold the right, correct?
I have an obligation to ensure that the statute does not conflict with the Constitution. There are higher courts that can determine whether my legal decisions about that are right or wrong.
It's based on fact, not your opinion, just for the record. Do you have that oath on file, and can you produce it for the record?
I'm not going to entertain giving you a copy of the
Would you
oath
be-
now.
would you be willing-
You can seek the process. You know how to do public records requests.
Will you be willing
stop-
to-
I'm answering your question. Stop talking. I'm entertaining this circus that you are.
It's just a yes or no answer.
That you are engaging in right now.
It's just a
in
yes or
way.
no
Stop
answer.
arguing with me. You obviously know how to initiate a public records request under Chapter 119. You can seek out whatever records that you need to seek out from the Florida Bar or the Judicial Qualifications Commission or the Florida Supreme Court or the 8th Judicial Circuit to determine whether or not you can have a copy of my oath of office. Certainly, you may go about doing that.
Are you willing
I'm
to
not going
state
to
it
go
for
get
the
it out of a
record
file
on the
and
oath?
hand it to you.
Are you ready? Are you willing to state your oath on the record?
I am not going to entertain this process anymore.
Let the record
Yeah,
show that
okay.
the judge refused
All right.
to honor his oath.
I'm done with this little charade, okay? Mr. Salter, you're still appointed to this case.
Yes, sir, Your Honor. I have not had any contact with Ms. Williams since you appointed me a couple court dates ago. I'm asking for a continuance to the September docket.
Okay. I assume you don't want his services.
No, I don't. I waived that long ago.
Are you going to go through the questions with me here today in
No.
order for me to determine whether or not?
No, because you don't have you don't have jurisdiction to do that.
Okay. You're going to be either brought to trial or enter a plea one way or
Go
the
ahead
other.
and set the trial.
Okay. All right.
Jury trial.
All right, you won't go through the Ferretta inquiry. I'm making a note of that record here today. You will not go through the Ferretta
I will
inquiry
be
with me.
representing myself.
It's required that I go through the Ferretta inquiry. Yes, the Constitution and the laws of Florida require me to go through that.
No, don't.
Okay, all right.
They require you to.
You are still represented by Mr. Salter. We'll set this case for trial next month. It'll be a jury trial in September. We will have jury selection on September 2nd. That is a Tuesday. This was your trial status conference and your pretrial conference.
What date is that?
That's a Tuesday. You need to be here
What date?
September the 2nd. It's a
That's
Tuesday.
kind of soon. Is there anything you can do a little later?
You've been asking for a trial for months, ma'am.
That's just. It's not a month away. I need at least a month. Can you, do
you
it
need
a
at
little
least
later?
a month.
Your Honor, I'm asking for the continuance to the September docket.
I'll give to when?
To September.
I'll give you a
9th.
trial status conference on, Mr. Salter, you do still represent her, so for your purposes, I'll give you a trial status on September 9th, and then jury selection will be October 6th, okay? Sign your notice to appear. Remember what the court ordered, and you'll receive a copy of the written order.
The final moments bring closure. The judge ends the debate, confirms legal representation will remain, and sets firm trial dates. The defendant's objections no longer change the outcome. From a third-party view, the silence that follows says everything. If you enjoyed this breakdown, hit the like button, subscribe to the channel, and we'll see you in the next video.